Hi, I'm Philip C. Curtis from P. Curtis & Associates. I'm an immigration attorney that specializes in family-based immigration law. One of my specialties is the adjustment of status process. Today we're going to talk about the adjustment of status process in the context of a family-based immigrant visa petition. Thanks for stopping by. Before we get into a substantive discussion of adjustment of status, I wanted to take a moment to define adjustment of status for those of you who are new to the subject. Adjustment of status is a legal process by which someone who is already in the United States in the non-immigrant visa category can become a lawful permanent resident. Adjustment of status shouldn't be confused with change of status, which is another legal process by which someone who is in one immigrant or one non-immigrant visa category changes their status to that of another non-immigrant visa category. Now that we understand what adjustment of status is, let's learn a little bit more about the requirements for adjustment of status. In order to qualify for adjustment of status, you must meet three basic requirements. The first requirement is that you must be in the United States legally. If you enter the country illegally or otherwise enter the country without being inspected by an immigration officer, you likely do not qualify for adjustment of status. The second requirement for adjustment of status is that you must qualify for an immigrant visa that is immediately available. We'll talk about this a little bit more later. The third requirement for adjustment of status is that you must be in good standing or in status with your current visa. If you overstayed your visa or otherwise fell out of status, you may not qualify for adjustment of status. So those are the basic requirements for adjustment of status. However, as with many things, there are some exceptions to these general rules. The first exception relates to people who may have entered the country illegally. There's a law known as 245I, which allows people who entered the country illegally to adjust their status by paying a penalty of $1,000. In order to qualify for adjustment of status under 245I, you must be the beneficiary of an immigrant visa petition that was filed between 1998 and April 30th, 2001. The second exception to the adjustment of status requirements relates to immediate relatives of U.S. citizens. The requirement that you must be in status to qualify for adjustment of status does not apply to immediate relatives of U.S. citizens. Immediate relatives of U.S. citizens are defined as children, spouses, and parents of United States citizens. In most cases, adjustment of status is only one of two options for a foreign national to obtain lawful permanent residency in the United States. The second option is known as consular processing. In consular processing, the foreign national returns to his or her home country and applies for the visa at the U.S. Embassy abroad. This is usually not a great option because it involves separation of family members for a long period of time. That's why in most cases people who qualify for adjustment of status prefer to go that route. There are three main advantages to adjustment of status. First of all, the adjustment of status applicant is allowed to stay in the United States while their adjustment of status application is pending. Second, the adjustment of status applicant is entitled to apply for an employment authorization document which allows him or her to be employed in the United States while the adjustment of status petition is pending. Thirdly, an adjustment of status applicant is entitled to apply for a travel document which will allow him or her to travel to and from the United States while the petition is pending. In most cases, adjustment of status is generally a preferable method. However, the filing fees for adjustment of status are quite a bit higher than consular processing. But in most cases, I think it's worth the extra cost. So now we understand what adjustment of status is. We know about the requirements for adjustment of status, and we also learned about some of the benefits of adjustment of status. Now let's move on and talk a little bit about the adjustment of status process. The adjustment of status process begins when the applicant files a petition with the USCIS, or the United States Citizenship and Immigration Services. Once the USCIS receives the petition, they will issue receipt notices acknowledging that they have received the petition and it has been accepted. Shortly thereafter, the USCIS will issue a second notice requesting that the applicant appear to have his or her fingerprints and photographs taken. Once the photographs and fingerprints have been taken, the USCIS will issue an employment authorization document and a travel document. This, of course, assumes that you've applied for an employment application document and a travel document, but this is customarily done when one files a petition for adjustment of status. With the employment authorization document and the travel document in hand, the applicant is allowed to legally work in the United States and travel to and from the United States while the application for adjustment of status is pending. Sometime thereafter, the USCIS will issue an appointment notice. The appointment notice requires the applicant and the petitioner to come to the USCIS district office for an interview. At the interview, the USCIS official will review the file and make sure all the required supporting documentation is in order. After the interview, the USCIS official will adjudicate the petition and approve or deny it. If the petition is approved, in about 2 months, the applicant should receive his or her green card in the mail. So that's the end of the adjustment of status process. However, if your application for adjustment of status was based on marriage to a U.S. citizen, and you were married for less than 2 years at the time you filed the application, you will be issued a conditional green card. Your conditional green card will be valid for a period of 2 years. At the end of the 2-year period, in fact 90 days before the end of the 2-year period, you're required to file a petition to remove the conditions on your residency. This petition must be filed jointly with your spouse. At the time you file this petition, you'll be required to provide certain documentation to establish that your marriage was entered into in good faith and that you've been living with your husband or wife as a legitimate married couple since you were issued your green card. In order to prepare for this petition, it's a good idea to make sure you keep the required supporting documentation and set it aside. Some examples of this documentation include joint bank statements showing commingling of financial assets, mortgage statements or lease agreements showing joint ownership of property, birth certificates of children born to the marriage. This is probably the best evidence of a bona fide marriage. Insurance statements showing your spouse named as a beneficiary, affidavits from third parties testifying to the nature of your relationship, and other similar documentation. Put this stuff aside. When the time comes to file your petition to remove conditions, you'll be in good shape. Hope this video has helped you understand a little bit more about the adjustment of status process. For more information about adjustment of status or to learn more about my services, please visit my website. Thanks for stopping by.